not, because that's probably what he's trying to do. And again, I'm an attorney, so I'm a pessimist about everybody and a cynic. So maybe the people you guys see in your job are upstanding and decent folks that wouldn't do that to you, but people only come see attorneys when they do. So that's all I see. That's kind of my worldview, is when people don't do the right thing or aren't nice to each other. Contract price, this is the important one. So you want to fill in how much you're getting paid. You don't want, we want to make sure this number's correct. If they says, oh, we're just going to put this number down and we'll fix it later, or we're just going to just go with it, we'll leave it blank, and then we'll see when we're done with the job. Always insist that there be a dollar amount plugged in there, because if you don't, then you got to go hire a lawyer, go in front of a judge, and you have a lot harder case to make. So definitely require that. Let's see. As I was mentioning, it's let's see. Okay, I'm at Article 4. So it's industry standard sometimes, I guess, to pay for supplies and then progress the payments as people are going forward. This is where you'd put it in. You can just handwrite it. Again, a contract, there's no, let me back up. So there's no required form of a contract in Texas or the United States. It can be on a napkin. It can be written in any language. There's no form contract. So if you see something on here, if you're using this one and you want to change it, feel free to cross it out, handwrite something in there. It's still good. As long as both parties initial it, you're fine. So don't, if you have a contract and it's not working for your specific situation, you can always type a new one up or just use pen and both initial it, and it's as good as if it was typed up and looked official. So this is where you would put the time frames, and you could just handwrite it in as to what, how you wanted to get paid, how the owner was going to pay you. And this is an important one, because if the owner doesn't make the payments that are required under the contract, you're allowed to stop working on the contract. In other words, if there was an agreement that you were going to get paid half when half the job was done, and he says, oh, give me 3 more weeks, I need blah, 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 you're within your legal rights to stop work and just walk off the job site. That's what the contract is. It's an agreement. Now, I mean, you guys can change it, but realize that you're in a little bit of an upper hand, because you know you can walk off the job. Say, that's fine, but it's going to be $100 extra because I've got XYZ costs, or $1,000 extra. Here's why, and then you've got a little bit more leverage on him to try to work it to your advantage. So I would say, I've heard a lot of folks that they don't get paid their final payment and those kind of things. We'll talk about how to get paid on those with the lien, but don't do work for free. I mean, no business survives doing that. So you guys already know that. Let's see. Okay. Article 5. This says that any alteration or deviation, which are special words for a change order, will be made upon a written order. So it'll have to be, you can't just tell you, hey, I need you to put this on. It's got to be written. Again, the whole idea is these aren't for when things are going good and everybody's happy. This is for when things are going bad. And you want to show the judge, no, I had a change order. It's right here. And again, additional charge will be added to the contract price. So you want that on the change order, and you want it signed by both parties. So if whoever you're working for says, oh, nope, not going to pay it, you can take it for the judge. And the judge, it'll be real simple for the judge if those signatures are on there. Here's kind of what I was talking about earlier. If payment is not made when due, contractor may suspend work on the job until all payments have been made. A failure to make payment in a period of, you can fill in your days, 30 days, 15 days, whatever your business needs, from the due date shall be deemed a material breach of this contract. That's fancy legal terms to say I don't have to do any more. A material breach means this contract's void, and I don't have to stick around. I can go find another job or do what my business needs because you didn't pay me within the following days. Here's some things. Generally, these following provisions protect the owner, but they're standard. This says just kind of like you know what you're doing, workmanlike manner, in compliance with building codes and applicable laws. You'll furnish a plan if one is needed. If, say, the electric work needs to be done, this just basically says you'll find an electrician that's licensed, or any other job that needs to be licensed. This allows you to hire subcontractors if you need. This says that if they pay you, you'll remove the liens from their property, and we'll get to that. Change orders shall be in writing and signed by both owner and contract. This is here twice. It's important because a lot of times, I mean, I've just heard people, you get into a job and you say, well, I don't know, now the client is saying we got to put in a different kind of marble, or a different kind of, oh, we really need this. And according to the contract, you don't need it unless you get paid, right? Because you're not in business to do free work or give away free materials. This contractor, so you'll get all the necessary permits, agrees to remove all debris and leave the premises in a broom clean or broom swept condition. That means no junk on the floor, that kind of stuff. Here again, you know, in the law, the easier you can make it for a judge, the better. So you might think, well, why is number 9 in there twice? Well, if you can take it to the judge and says, Judge, it says twice in this contract that if they don't pay me, I can walk off the job. Even better. So 9 basically says, if you don't get paid, you're done. 10 is an arbitration clause. An arbitration is something where you don't go to a judge, you go to what's called a third-party arbitrator. An arbitrator's neutral, kind of like the judge, and the idea of it is to lower legal costs for both parties. Generally, a trial might be 2 times more expensive than just going to an arbitrator. An arbitrator can usually hear your case sooner, and what the arbitrator will usually do is sign a binding arbitration order, and the judge will just then sign it, and it's like having gone to the judge, but you save time and money. As a lawyer, I'm not a big fan of arbitration. Costs me money, but it might be better for y'all. If this is something that you're able to opt in and out, you don't want to arbitrate with this person, you can cross it out. If the other party doesn't want to arbitrate with you before you sign it, just cross it out. It's not required. It's just kind of what you guys think is best. So remember how we said time is of the essence, and you have to do your best to get the job done. This one says you're not going to. It's called kind of a acts of God clause. So that means if there's a labor strike and you can't get a product, if there's a flood and you can't get to the work site, you're not going to be responsible for that delay. If you didn't cause it and there's nothing you could do about it, then you're not, you obviously, unless you are God, and then you're in trouble. But I don't think you have to show up to court. So, and here's a voluntary warranty for your work. If you want to put that in, you can choose the months. Okay, indemnification, this is more for the owner's protection. They might insist on it. Basically says if something goes wrong with your employees, agents, subcontractors, and they sue the owner, you're going to pay the owner whatever costs they incur to defend that. So basically you're saying, I'm responsible for my subs and employees. You don't have to worry about them suing you, because if they do, I'm going to step in and pay everything. And by you, I mean your business, not you personally, hopefully. If I was drafting this for you guys, I might remove it and make them say, no, we want an indemnification clause, because, hey, if you don't have to do this and they don't think about it, perfect. It's something the owners will probably want. Here's, if you have insurance, this is, and I hope all of you do, depending on the work you do, this is just an agreement that you'll keep that insurance in place and fill out the dollar figures here with the amount of your insurance. And this is just something that, again, the owner might request, but if I was drafting it for y'all, I might leave out. All right, let's see. All right. So this is important. Name, registration number of any salesperson who solicited this. Witnesses aren't required for a contract in Texas to be valid. They're helpful because you can't say, I didn't sign that. If you've got witnesses, but they're not required, you can't find a witness, go ahead and just sign it. Name of the owner. You want to insist on the name of the owner or somebody with a high up business title, vice president, director, those kind of things. You don't, if it's somebody that washes the car for the company, they probably can't bind the company to this contract. So you want to ensure, if it's Nike, that you're getting some kind of vice president or director or somebody with authority on behalf of Nike to enter into the contract rather than just some generic person. So you want to make sure that who you're talking with and who you rely on actually has the authority at the business to do it. Usually that's not going to be an issue, but it's just something to bring up. Here's, if you've got a license, you fill all of this out, and basically each party gets a copy of the signed contract. You keep it in a safe place. There's a thing called a statute of limitations in Texas, which means certain cases, if they get too old, you can't bring them anymore if you haven't already done it. So if somebody breaches a contract with you in Texas, you've generally got 2 years to sue them on it. So after 2 years, you can kind of get rid of your contracts because you can't sue on them anymore. So, but I would recommend not waiting until the last minute to sue somebody. Try to get it in as soon as you can, just to protect yourself. All right, now we're going to talk about how to get paid and how to enforce your rights and ensure you under the contract. So there's a couple different options. One is you could just sue somebody or ask for arbitration. The easiest way, if it's not a large amount, if it's under $10,000, everybody in their community has a Justice of the Peace Court. And to file a lawsuit, you don't need a lawyer to do it. They have a form. It costs, I think, $43. And the people at the desk when you go into the JP court, they're not going to be very nice about it, but eventually, if you put up with enough, they'll help you to figure out what you need to do. The courts are set up